so we'll just jump right in. Sorry I missed everyone last week. Back in black. Gosh, I got just caught in the rain, so I probably look like a mess.
Yeah.
It was like out of nowhere torrential,
No, it was crazy.
right?
How
So was
many
there
people do we have here with us? I'm
um
just curious. I'm totally learning how to do the Zoom too, so I'm
oh
not Zoom.
yeah, right. So I think we have about like 12 people in.
Okay, cool.
Yeah. And yeah, feel free to when we go over the questions, feel free to enter your answer in the chat or just say it out loud. Might be helpful for them. Is there any specific topics that you guys want to start off with?
Mine's definitely practices and principles.
Practice and principles? All right. Sounds good. I'll start there.
The greatest you place is in the unique food that you make or the character that you are. But the component of that
And practice and principles. Am I missing it?
you are constant.
Like general principles of agency, practice of realistic.
Mine's usually at the top, but yeah, I don't see it on yours. Let me see.
Hmm. Yeah, no, I don't see it either.
Right. Mm. Hmm. We could do practice of real estate maybe, or general principles of agency.
Yeah, let's do general principles of agency. That's probably it.
Well, sounds good. Start here. So, and I'll make my screen bigger so everyone can see it. Oh no. Put my chat. Okay. So in real estate transactions, a real estate salesperson has a direct fiduciary relationship to the A, other sales people participating in the transaction, B, cooperating broker, C, buyer's agent, or D, sponsoring broker.
The cooperating broker.
And fiduciary means person in position of trust held by law to high standards of good faith and loyalty. And I heard you said cooperating broker?
I thought it was cooperating broker. I was gonna say, what's the difference between the sponsoring broker and the cooperating broker? Or are they just throwing that in there to confuse you?
Yeah, exactly.
Uh-huh.
Right. So cooperating broker, actually, I'm trying to, it is confusing. So cooperating broker could be the other agent you're dealing with, and sponsoring broker is going to be the brokerage that you work under.
So it should be sponsoring then, I would think, but I don't know.
Because salespeople participating in the transaction are buyer's agent. Okay, so I have D. Let's see.
Yeah.
And D is correct. I know this one is super confusing. I was even gonna say a whole deal, but I mean A, because other salespeople in the transaction is just you assuming that you're working with another agent. But sponsoring broker is the one that the brokerage that you work for. So
Mm.
in this case, like Keller Williams Greater Metropolitan, and then so you would have a direct fiduciary relationship with Keller Williams Greater Metropolitan. I'll put the question and answer in the chat. All right, good job. A person who is known as an attorney, in fact, is someone who has A, power of attorney, B, special agency, C, general agency, or D, implied authority.
A,
So attorney in fact.
fact. Hmm.
All right, so we have B. No, okay. Let's see. B.
What is
And the
power?
correct answer is power of attorney. So a person who has power of attorney is known as the attorney in fact. So kind of in your notes, power attorney equals attorney in fact. And just knowing the various like terms for each and like the AKAs for all of them, because they'll throw in like the same word but use it differently to try to trip you up. And knowing the various agencies and the relationships to the other party is definitely very helpful, because they can get super confusing. All right. A broker takes a listing from a seller. In the third month of the listing, the seller had a fatal heart attack. Regarding the listing agreement, which statement is true? A, the heirs must work with the broker to get the estate sold. B, the broker must remove the sign and the lockbox. C, the broker must now reduce the price. Or D, the broker must disclose if the seller had the heart attack at the listing.
A,
A, the heirs must work with the broker to get the estate sold.
oh, the broker has removed the sign, but don't they have a contract with them? Wouldn't they keep going or?
So, yes, but the broker would have to sign a whole new contract with the heirs.
Oh, okay.
Yeah. Yeah, this one obviously. Wait, so which statement is true? The broker must remove the sign and the lockbox. So they must remove the sign and lockbox because immediately they'll have to take it off the market to then get the listing agreement signed again to then basically relist it. But this is confusing because it would be hard to know that if you didn't know that that was the process and how you listed the property. No, I mean, so by operation of law, once the client or broker in an agency relationship dies, the agency ends. And then another, again, like you would have to then have a brand new contract with relatives or heirs of the property.
Gotcha.
Okay. So in a listing agreement, the sales agent is described as the A, buyer's agent, B, principal, C, sub-agent, or D, agent.
Listing agreement, the sales agent. Hmm.
Yeah, this is tricky because it says in a listing agreement and then it name drops the sales agent described as the, so we have D, and it is sub-agent. Actually, so an agent is a sub-agent in the listing. So it's really C and D. Again, this is a poorly worded question, but an agent is a sub-agent in the listing. The listing belongs to the broker, and thus the broker is the agent. The sales agent is an agent of the broker, making them a sub-agent under the broker. The listing agreement is between the broker and the seller, not the buyer. So it's saying when you do have a listing and you are the listing agent on the property, technically the broker is the agent and you are the sub-agent working for the broker.
Agent of agent.
Yeah. During an initial interview, a buyer signs a buyer's agreement with an agent. The agent begins sending this potential buyer some listings from the MLS, and the buyer has the agent show them a few properties. Then the buyer asks the agent to negotiate on their behalf and prepare an offer. When the agent prepares the offer for the buyer, the agent discloses that they represent the buyer. This type of agency is regarded as A, ostensible agency, B, listing agency, C, actual authority, or D, universal agency.
Right.
And this, an
It's-
agency, definition of agency is a relationship of trust created when one person, the principal, gives another person, the agent, the right to represent the principal in dealings with third parties.
It's universal. Listing agency. Which type of agency is regarded as? Two properties and the buyer as the agent negotiating on behalf of preparing an offer. Well, I don't think it's universal because that means it's out of state, right?
Universal,
Is out of state.
remember the definition.
Pretty sure it is. I've never heard of, I don't think I've ever heard of ostensible agency. I don't think I've heard of that.
Yeah, I feel they
Oh,
do throw in some,
I don't know, maybe listing agency. What does everybody else say? Buyer signs a buyer agreement with an agent.
I'm gonna guess C. Yeah, B or C.
let's try it. Okay,
Yeah,
so it is
good.
C. Yeah, good job. And so listing agency may describe the relationship between broker and seller, like our previous definition or our previous question. And then actual authority is when the principal through written instrument gives authority for representation. Universal agency describes the level of authority of an attorney in fact. And then ostensible agency is agency without evidence of authority, plausible but not actual representation. That it gives you the definition. I don't even know if I'm saying it right though. Right, good job, Brad.
Write this one.
Yeah, and when you're taking the test, just kind of like talking yourself through it, like what you're kind of doing, is also very helpful. Even though like you obviously can't discuss with anybody else, but just going over the definitions in your head on what each of them mean and what best matches what they're asking for. All right. Well, a listing agent is showing a rental property. It becomes clear that the buyers are about to disclose a confidentiality. They recently won a large settlement in a personal injury case and have unlimited funds to spend on the property. The agent A is a buyer's agent and will keep the buyer's confidentiality. B is a dual agent, so it is okay if the buyers tell the agent this information. C owes no duty to disclose to the buyers any relationship between the agent and the seller. Or D should tell the buyers before showing the property not to disclose any confidentiality.
I would say D.
D?
As a buyer's agent will keep buyer's confidentiality.
All right, and that is correct. Good job. So the agent should tell the buyers before showing the property not to disclose any confidentiality. Good call. So basically, if you were the buyer's agent, this is what you should tell your buyers prior to walking into the showing. So as the buyers are about to tell the sales agent a confidentiality, the agent should tell the buyers before any home is shown that the agent represents the seller, and that all confidentialities disclosed to the agent will be told to the seller. In this question, the agent is the listing agent, and unless there is disclosure that the agent is a dual agent, the presumption is that the listing agent represents the seller. So in this case, they didn't say that the listing agent represented anybody else besides the seller, so we can't assume that they're dual. So they try to trick you. Right. A broker charges a fee to assist parties to a potential real estate transaction in communicating, negotiating, and performing the terms of an agreement. Yet the broker is not representative of either party. In this situation, the broker would be defined as A, dual agent, B, buyer's agent, C, facilitator, or D, seller's agent.
Facilitator. See?
Really good, Rosemary, thing like that.
Facilitator?
I don't know.
And that is correct. Cool. Good job. So a seller is represented by a broker under the terms of a listing agreement. A buyer is represented by a broker under a buyer-broker contract. A dual agent is when a broker represents both the buyer and seller in the same transaction. And then when the broker is just helping the parties of a potential real estate transaction, the broker is just the facilitator. Right. For a broker to act for more than one party in a real estate transaction without the knowledge and consent of all parties is A, ethical, B, grounds for disciplinary actions, C, contrary to Board of Realtors bylaws, or D, acceptable as long as no party suffers actual monetary damage.
Mm,
I think B.
B? All right. Correct. Good job. Most states allow a broker or sales agent to act as a dual agent only if parties give consent in writing. So grounds for disciplinary action is called. Yeah, so we can't be dual agents unless we have signatures from both parties. The best description of principal is A, a landlord, B, a customer, C, one who employs a broker to represent his interests in matters of real estate, or D, an owner of real estate.
Let's see. One employee's broker represents his interest in matters of real estate.
C.
Yeah. I think C too.
Yeah, good job. Mhm. So a customer, that is what they are before they're your client. So client and principal, so client equals principal, principal equals client. They'll use both. So the agent represents the principal and therefore owes a fiduciary duty to the principal. An agent works with, but not for, a customer. Okay. A licensed real estate salesperson is permitted by law to represent A, himself as a broker, B, any interested party, C, one or more brokers, or D, his sponsoring broker only.
D.
D?
Mhm.
Good job.
Yeah, D.
Yeah.
Yeah.
Good job. Yeah. Good work, guys. All right. Let's see, back to our dashboard. Which one we should do now? I'll hide this so that everyone can see all the options. So pop in ownership. financing? Okay.
Where did it go?
I'm down for. Okay. See. And then we can do land use control after. So financing or laws and rules. Sounds good. I don't think we've done
about-
laws in a while, so we'll do that one.
The laws and rules, yeah.
Wait. Laws and rules. Okay, yes. Mine's good. License laws and rules. This one, okay. Perfect. Then after that, we can do land use. Okay. All right, cool. So this is a 20 question one. So this will definitely cover a lot of the Ohio question, hopefully.
Sure.
So which of the following is a violation of license law? A, having acted as a broker without authority, impeded the ability of a principal broker to perform any of the duties, or impeded the ability of a management level licensee to perform the licensee duties. B, hire other salespersons from different brokerages. C, offer free CMA to a landowner. Or D, offering training to pre-licensed agents. So which of the following is a violation of license law?
I think it's A.
Okay. Okay.
Mhm.
Good job. Yes. It is A. So in Ohio, license law prohibits practicing real estate without a license or impeding the ability of a broker to perform their duties. Yeah, so obviously you can't practice real estate until you get your real estate license. And the longer the answer, that was the right answer in this case. So after recording an affidavit of lien with the recorder's office, the broker shall provide a copy of the lien affidavit where a contract of sale or other conveyance of the lien property has been entered into the A, prospect of the transferee, B, owner of the lien property and the prospective transferee, C, superintendent, or D, owner of the lien property.
I think it-
And to give the definition of a lien is a non-possessory interest in property, giving a lien holder the right to foreclose if the owner does not pay a debt owed to the lien holder, a
transfer.
financial encumbrance of the owner's title.
Prospects of the transferee.
Okay.
I don't know.
It is B. I did not know this one. B, so to the owner of the lien property and the prospective transferee.
It's close to both.
Okay. So Ohio Revised Code, you don't need to know the exact codes or anything like that. So paragraph states that when a contract for sale or other conveyance of a lien property has been entered into the affidavit after being recorded, shall be served either by personal delivery or certified mail upon the property owner, and if known, upon the prospective transferee. Alright. Lien affidavit to the owner. So this is who gets a copy of the lien affidavit. They both get copies, especially when it's recorded at either the county office or the recorder's office. That's the lien. If given the choice, what type of listing agreement would a seller probably prefer? A,
A.
exclusive agency agreement. B, net listing. C, open listing. Or D, exclusive right to sell.
Oh wait, which one is it? I think it's a D.
D?
I think it's D. It was A. Damn it.
Yeah. So like so we actually use the exclusive right to sell as agents. The exclusive agency agreement is like if the seller, or I mean, if the sellers find a buyer then they don't owe you commission. But if you do all the prepping and things, you represent the sellers and you find a willing buyer, obviously, or if you find the buyer, or if you work with a buyer's agent in the transaction, you are entitled to commission. So the exclusive right to sell guarantees commission no matter who finds the buyer. If the seller finds the buyer, then an exclusive agency states that if the seller finds the buyer, then the seller saves the commission and doesn't owe. And then this type of listing probably would be the seller's preference, because then they wouldn't have to owe commission. Then an open listing is not given to any one broker, but is open to all brokers. And then with a net listing, the seller receives only the net amount of the sale price. And net listings have been prohibited in many states. Yeah. An agent wishes to specialize in the sales of commercial property. What should they do? Choose best answer. A, seek additional education in order to be licensed to sell commercial property. B, find a broker that specializes in the sales of commercial property. C, stay with the same brokerage. Or D, must have done at least 20 residential transactions to sell commercial property.
Stay with the same brokerage. See.
C.
Yeah, did I
You
said
say
C?
C?
I said C too, yeah.
Okay, yep, C. Good job. Yeah. And what's cool with KWGM, we actually just started kind of building a commercial tranche that an agent is taking over. So yeah, you can do commercial real estate while having your real estate license. There's no specific license that you need. Okay. Homosexuality is protected under what federally protected class? A, sex. B, homosexuality is not protected under any federally protected class. C, natural origin, or D, familial status.
B?
B.
B? Right. Good job. Correct. Okay. Next, how many hours of continuing education are required by an Ohio licensee over a 3-year reporting period? A, 20 hours, B, 26 hours, C, 30 hours, or D, 35 hours?
C.
30.
Correct. Yeah, so just think 3 years, 30. So the 3-year reporting period is going to be 30 hours. It's just weird, and within your first year, those change. Okay, the principal broker has the following duties except A, oversee and direct operations, B, comply with office requirements, C, prepare listing agreements, D, comply with fair housing documentation requirements.
Maybe C?
So, correct. Let me
Mm.
see.
Yeah.
Because brokers have obligations to have compliant offices. So preparing listing agreements, that is done by an attorney or a lawyer. What's the question rationale? Brokers have obligations to have compliant offices. I don't know if this helps. Okay. So for a minimum of how many years must a broker keep records? A, 3, B, 1, 2C, or D, 5?
I think it's A. I think.
Okay. Couple A's. Correct. A broker must keep a copy of all transactions for a minimum of 3 years. And copies basically mean like electronic or physical copies. But majority of them are going to be electronic. And you'll keep a record of your transactions within the CRM we use. Okay. If the superintendent pays an amount from the recovery fund in settlement of a claim toward the satisfaction of a judgment against a licensed broker or salesperson, the license of the broker or salesperson is automatically suspended. B, the license of the broker or salesperson is automatically revoked. C, there's no action against the broker or salesperson as the fund is set up to protect the public. Or D, the salesperson or broker must pay a fine of $2,500.
Pays an amount from in settlement of a claim towards.
And the superintendent is the administrator of the real estate license law and the division of real estate.
Gonna be A?
I would say A.
I would think A, but
That is correct. Good job. And so it is the license of the broker or salesperson is automatically suspended. Kind of knowing what each punishment for a specific, like a specific, almost what is it like? Issue when you're getting your license. So what you have to do, then know what you have to do to then be fined $2,500, or what to not do so you don't get fined that. That's what I was getting at. And then what it entails to be revoked and suspended. So kind of having like a little idea of each one is going to be super helpful because they do ask various questions about this. All right. A sales agent states in his advertisements that he will provide a free room addition to anyone who buys one of his listings. What is true? This is unethical as a sales agent is not allowed to offer an improvement in real estate as an inducement. This is legal as long as this inducement is disclosed between the buyer and seller. This is legal as long as this is noted on the sales contract. This is unethical as the sales agent may not offer anything as an inducement.
It's tricky, but I'm thinking maybe B, just because it's disclosed between the buyer and the seller. I don't know.
That's a good point.
Is it unethical?
An advertisement.
Oh, it's advertisements. Wait. You think it's A?
Okay.
No. No.
What's B? Did you say B first?
I thought said B first because it was disclosed as long as it's disclosed between the buyer and seller.
Yeah, wow, that's crazy. I actually did
It's
not know.
legal as long as it's noted on the sales contract.
So what is true? This is legal as long as this is noted on the sales contract. That's crazy. I actually did not know that. The sales agent is not allowed to offer real estate or improvements on real estate as a prize in a lottery or game of chance. When offered as an inducement, this must be noted in the sales contract and disclosed to the buyer and seller. So technically it really was B and C,
Yeah.
but
The
it
best
was poorly worded.
as my teacher would.
What is it?
I said the best answer is C, as my teacher would say.
Yeah, right. A buyer makes an offer to buy a house and faxes the offer to the seller in another state. The seller, upon receipt, signs the offer, intending to mail it back to the buyer the next morning. In the meantime, the buyer telephones the seller and withdraws the offer. What is true? A, there is no contract as long as the acceptance has not been delivered to the buyer. B, there was never a rightful offer as the offer was faxed and the seller must have received the original offer. C, both parties are now bound to the terms of the contract. D, there is a contract as the seller has accepted the buyer's offer. A.
Wait, let's see. In the meantime, the buyer. True.
Question.
There's no contract as the acceptance has not been delivered to the buyer.
And
So-
that is
Offer.
correct.
Intending to mail it back. I would say
Yeah.
A. Yeah, you didn't get it.
Yeah, so they need to both be aware that the offer has been accepted for it to be under contract and execute contract. So there is no contract because the acceptance has not been delivered to the buyer. So the buyer, before receiving that the seller has signed it, withdrew their offer, so there's no contract. So contract occurs when there has been an offer, an acceptance of an offer, and delivery or communication of the acceptance back to the party who made the original offer. Even though the seller had accepted the offer, it is not communicated or delivered back to the buyer. Thus, there is no contract. All right. A broker offers a seller a free trip to Hawaii in return for a property listing. What is true? The broker must disclose this on the listing contract. The buyer and seller must agree to this inducement. C, the broker must disclose this to any potential buyer. Or D, the broker must disclose this in the real estate sales contract. So a broker offers a seller a free trip to Hawaii in return for a property listing. What is true?
Broker must disclose the real estate sales contract.
So we have an A, the broker must disclose this on the listing contract. All right. And that is correct.
Hmm.
Good call. So just like the last one, the buyer's agent was advertising and they need to disclose it on the sales contract. We need to disclose it on the listing contract. So since the broker has the listing, he need only disclose this inducement on the contract between himself and the seller. If this was an inducement to the buyer, then it would have to be disclosed on the sales contract. So since the buyer is not involved at all in this perk of winning a free trip to Hawaii, it doesn't need to be disclosed to them in the sales contract, just the listing contract between the broker and the seller. What is the maximum number of DBA, do business as, names a broker is allowed to operate under? A, no more than 5, B, only 1, C, no more than 2, or D, no more than 3. What is the maximum number of DBA, do business as names a broker is allowed to operate under? Sorry, I didn't click one. B? Yeah, that's not hard one. Oh, actually, the correct one is no more than 5. The broker can have up to 5 business names to do business under. Interesting. I wonder, oh, this is a salesperson grammar. Well, it sounds like a broker question for that quiz. Which of the following grants the broker the exclusive right to represent the purchaser in the purchase or lease of property? Which of the following grants the broker the exclusive right to represent the purchaser in the purchase or lease property? A, buyer listing agreement. B, exclusive purchaser agency agreement. C, agency disclosure statement. Or D, consumer guide to agency relationship.
Oh boy. What do the broker grants the broker?
Of property. So which one grants the broker the exclusive right to represent the purchaser, so the buyer, in the purchase or lease of property?
Agency disclosure.
Is B?
Exclusive purchase agency agreement.
that is correct. Yeah, they try to confuse you because like exclusive purchaser agency agreement, like they're trying to get fancy with their words and trick you with that, but basically if the broker is hired by a buyer and the buyer will be obligated to pay the broker who has the exclusive right to represent the buyer. If the seller does not offer compensation, it is the exclusive purchaser agreement. So then the buyer would owe the commission, which is also a buyer's agreement, but you can say exclusive buyer's agency agreement, you could say exclusive purchaser agreement, agency agreement. They're just like having various names for it, but what we call is just a buyer representation agreement. Is the same thing. All right. Who administers the real estate license law? A, Department of Commerce, B, the police, C, Real Estate Commission, or D, Division of Real Estate.
The commissions. I think it's
Does not police. We're gonna say C.
Mm.
And actually D. So the Division of Real Estate administers the license law. Yeah, this one was tricky. But what can help you is when you do, everyone's gonna pass their exam, and when you do, you just hop on the Division of Real Estate website, which I can show you actually. And this is where you will see your active license. So it's going to be Division of Real Estate, is the Administrator of Real Estate License Law. Okay. When must a broker record a written release or satisfaction of the broker lien in the county recorder's office in which the lien was recorded? A, the owner must file the release of lien after the claim has been satisfied. B, within 15 days after the owner satisfies the claim. C, within 90 days after the owner satisfies the claim. Or D, within 10 days after the owner satisfies the claim.
Mm.
Any guesses?
Okay.
Thinking A?
Yeah.
I was thinking A too. Wow. So
Yeah.
10, within 10 days after the owner satisfies the claim.
Mm.
Good to know. I did not know this one. So when must a broker record a written release or satisfaction of the broker lien in the county recorder's office in which the lien was recorded? And that's going to be within 10 days after the owner satisfies the claim. Oh, I didn't even know there was a time period. No. State that release or satisfaction of broker lien must be recorded within 10 days after the claim is satisfied. And also good to know, key in this is of a broker lien. So this is saying specific lien. A person making an application to the recovery fund for payment must file an application to recover within A, 90 days after the termination of all court proceedings. B, 1 year after the termination of all court proceedings. C, 60 days after the termination of all court proceedings. Or D, there is no statute of limitations on claim against the recovery fund.
Mm. So,
Any guesses?
mm.
I'm
That's
sorry, I
it.
didn't mean to click anything, guys. All right, let's see. Okay, so it's B,
1 year.
1 year after termination of all court proceedings. States that the person making an application may not make such application more than 1 year after termination of all proceedings in connection with the judgment received, including appeals. Okay. Under the Ohio Real Estate Recovery Fund, the commission shall impose a special fee not to exceed $10 annually on each licensee filing a notice of renewal if the recovery fund is less than A, the commission may impose the $10 at any time, B, 3 million, C, 500,000,
think
D,
it's
2
A,
million.
for real estate, impose a special fee not to exceed $10 annually each license. Impose a $10 at any time. I think it's A, but
Okay. And just for everyone's definition, commission, the real estate commission is a 5-member committee that can adopt, amend, or rescind regulations concerning real estate licensing.
no, it's not. It is 500,000. Boy, are they tricky.
Right? Yeah, these are really tricky ones. I'm glad we went over this topic.
Yeah.
It's gonna be 500,000. Right here, actually, I'll put the question in. See if I have that.
Oh, if it's less than 500,000. Oh,
Next question, a buyer makes an offer on a property. The seller issues a counter offer. The seller issues a counter offer, which the buyer signed and the selling agent delivered to the listing agent. The buyer passes a FSBO and likes it better. So for sale by owner, he makes an offer to the for sale by owner and the seller accepts. Which of the following is true? A, the contract on the first house is not enforceable. B, neither contract is enforceable. C, only the first contract is valid. Or D, both contracts are valid. So this
I
is
would say
tricky.
D.
D. And that is correct. The buyer has just purchased 2 properties. Both contracts are valid. Yeah, good job. Which of the following is not a management level licensee? A, an associate broker. B, team leader. C, salaried licensed office manager. Or D, a new salesperson.
C. Management, which is not. Oh, wait, which is not.
I think it's D.
C.
Okay, you said D? Or C?
Yeah.
You said D?
I think-
Okay. That is correct. Good
Yeah.
job. So they are not a management, so being a new licensed salesperson or newly licensed agent, you're not management level licensee. So Ohio license law considers any licensee who is in position of supervision over other licensee is management level licensee. All right. That was a tricky section.
Mhm.
Okay. Let's go back and I think there was land use and control. Is that the other one we wanted to look at? Or land use controls and regulations? Where's that? Not this one. Okay, cool. Which is true about immobility of land? A, affects the value in both good and bad markets. B, increases the value of land in a bad market. C, increases the value of land in a good market, or D, has no effect on land value, or has no effect on value of land. So which is true about the immobility of land?
Mm,
Yeses, no.
affects the value of both good and bad max. A?
Okay.
Mhm. No, let's see, increase the value of land in a good market.
Oh, so immobility helps increase the value of land in a good market due to the fact other land can't be moved into the given buyers to give buyers more choices. So the forget what the acronym was. It DUH? I feel like there's like an acronym that is associated with value, and definitely knowing that would help answer this question. So immobility of land increases the value of land in a good market. So right now, land available, it's a good market, it's definitely going to be higher value. So think of it like the houses that are for sale are being valued higher because it's a good market. All
Is it-
right, so which part of a government's control of land sets the standards of construction for the protection of the public safety? A, zoning regulations, B, declarations and bylaws, C, environmental regulations, or D, building codes.
Construction for protection of public safety. Mm,
Question, no.
control of land, government's control of land. Sets the standards of construction for the protection of public safety. Building code or zoning.
So A, zoning regulations. C, there's some guesses. Oh, building codes. Oh, it's between both as well. So building codes, which part of the government's control of land sets the standards of construction for the protection of the public safety? Building codes. And so declarations and bylaws are private controls, so those are more like HOA. And then building codes set the standards builders must abide by when building in a subdivision. Environmental regulations would require that an owner disclose if they have any significant impact on the environment through their land use. And then zoning regulations affect how someone can use the land. Okay. Laws that regulate the types of activity that may be undertaken in different areas of a community are called A, setback regulations, B, building codes, C, zoning ordinances, or D, rights of way. The laws that regulate the types of activity that may be undertaken in different areas of community are called, all right, we have a guess of C. All right, 2 people say C. Zoning ordinances? You are correct. Good job. Zoning ordinances set forth general uses for property in various areas of the community. Example, residential, commercial, and industrial. A charge against a property owner to cover the proportional cost of street paving is A, assessment, B, equitable obligation, C, county tax, or D, ad valorem tax. So a charge against the property owner to cover the proportional cost of street paving is a assessment, equitable obligation, county tax, or ad valorem tax.
Where is real estate?
So we say A, assessment. Correct, good job. I only know this because I've recently had to deal with it. But yeah, so ad valorem tax is based on the value of the property. That's really good to know. And is the normal tax the property owners pay. An assessment is an actual charge against the property owner to cover costs of an improvement by the municipality. I can't say this word, but basically by your city. And a county tax could be sales tax. Equitable obligation would be the owner paying their fair share, like homeowners association assessment for like a new tennis court. So that's more like exclusive or yeah, exclusive to a neighborhood. Whereas assessment is like if the city updates sidewalks or the sewage system, they charge the property owners that live within the city over a period of time to have those improvements. And you guys can see that in Relist, which shows you all about the taxes and description of property. A valid exercise of the government's police power to restrict an owner's use and enjoyment of property includes A, deed restrictions, B, adverse possession, C, easement by prescription, or D, building codes. And police power is the constitutional power of state and local government to enact and enforce laws that protect the public's health, safety, morals, and general welfare.
Exercise of the government's police power. Oh,
I would guess a B.
First possession. No, building code.
It is
Hmm.
building codes. Wow, building codes about this. A tough one. So a valid exercise to restrict an owner's use of building codes. So deed restrictions are private controls on property, while building codes are governmental controls of property. Okay. So adverse possession involves one individual possessing another individual's property for a prescribed time period to gain ownership. Easement by prescription is when someone acquires an interest in property by using it openly without the owner's permission for a certain period of time, but does not acquire title to the property. All right, so this one's going to be building codes. And honestly, it's hard unless you read between the lines on this one, but the key word here is going to be government's police power. So when it said government, they regulate how buildings are built and control the property that are built with the builders. Oh, okay.
Good boy.
Oh, we ended up right on time. Oh, these were tough topics, guys. We did a great job. And then I will add in that document I had. I don't know if that'll help, the little study guide that I had. And then it'll bring you to some Quizlets that you can use. Oh, here, I'll put it in here. Oh, cool. This is what I used when I was studying for the exam, so hopefully that helps. It's not updated or anything like that, but definitely a cool document to use. Well, thank you guys so much for participating. I appreciate it.